1973, Roe versus Wade, writing for the majority, Justice Harry Blackmun, quote, "The right of privacy," it's now not a zone of privacy, but a right of privacy, "whether it be founded in the 14th Amendment's concept of personal liberty and restrictions upon state action, as we feel it is, or as the district court," which had reviewed the case before it went to the Supreme Court, "determined in the 9th Amendment's reservation of rights to the people, is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. We therefore conclude that the right of personal privacy includes the abortion decision." Close quote. You have written that that majority opinion was 51 pages but contained not a line of legal reasoning.
That's right. What you get in there is a history of abortion in the Egyptian days. You get history of abortion under English common law. You learn about the attitudes of the American Medical Association towards abortion. You learn all these things. All of a sudden, he says there is a right of privacy and is broad enough to cover abortion, and that's it.
And that's it. It's simply asserted in the most brazen possible way.
Yeah.
All right. 7 justices of the Supreme Court, 7 out of 9, signed on to that decision.
That's right. You don't surprise me.
But the point is, you argue your point of view as if this activism were somehow errant, and obviously errant.
Oh, no. It's going on all the time. It's a mistake. It's a perversion of the judge's function. But it is the dominant view on the court today.
They've all signed on to it.
Not all.
Not all. 1992 now, Planned Parenthood of Southeastern Pennsylvania versus Casey. Because medical science had made it clear that fetuses were in fact viable, that is, that they could live outside the womb during the 2nd trimester of the pregnancy. Now, in Roe, the court has set up this schema where there's a 1st trimester, 2nd trimester, 3rd trimester. The court in the Casey case throws out the framework of Roe, the 3-trimester framework of Roe, but it refuses to overturn Roe, citing the doctrine of, you'll have to help me with the pronunciation,
stare decisis. Precedent.
Right, and that is the need to ensure the stability of the law by deferring to precedent. That was reasonable, wasn't it? Isn't that something that a conservative...
Well, no. It wasn't reasonable there because they did, in fact, change Roe. They didn't adhere to Roe.
They did heave a lot of it out.
Yeah, and changed it. And secondly, in constitutional law, precedent is less important than anywhere else because if it's a statute or a common law decision, that Congress can say, we don't like what you've done, and change the law. If the court makes a bad mistake about the Constitution, nobody can cure it except the court. And that's why precedent is less important in constitutional law than it is elsewhere.
So at any moment in American history, the 9 justices of the Supreme Court have to be especially alert to the possibility that their predecessors erred. They have to be especially alive to the possibility that they might need to overturn a previous decision.
That's right.
That's right.
You get, as Scalia points out in the Lawrence against Texas case, in Casey, they talk a great deal about how we can't overturn this because of precedent, because of... or we'd be giving way. And when they come to Lawrence, which is the homosexual sodomy case, they do overturn the precedent. Only of 17 years standing in Bowers against Hardwick, which says you can have a homosexual sodomy law. And so every reason they gave not to overturn Roe, they gave the opposite direction to overturn the Texas sodomy law.